Good afternoon and welcome to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to give everyone an update on what's been going on with the Apex Doctrine. And we have a new amendment by the Florida Supreme Court. This actually occurred in August, on August 26th of this year. The Florida Supreme Court amended Florida Rule of Civil Procedure 1.280, and basically to expand the Apex Doctrine. So we're going to take a look at that. Now, how many of you know what the Apex Doctrine is? Probably a lot of people don't know unless they deal specifically with the issue. But Florida's version of the Apex Doctrine basically protects only high-level government officials, really from being deposed, from being, quote, harassed in discovery. And what it's been described, and I think in the Suzuki case, that's 284 Southern 3rd, 1107, and that was a first DCA 2019 case. So they described the essence, quote, the essence of Florida's Apex Doctrine as follows. An agency head should not be subject to deposition over objection unless and until the opposing parties have exhausted other discovery and can demonstrate that the agency head is uniquely able to provide relevant information which cannot be obtained from other sources. And the first district in the Suzuki case had observed that the doctrine was only clearly established in Florida in the government context with respect to high-ranking government officials. And at that time, the first district said that no Florida court has adopted the Apex Doctrine in the corporate context. There was a dissent by Judge Thomas in the Suzuki case, and he maintained that, quote, the rationale of the doctrine is equally applicable in the private sphere. The courts cannot countenance unjustified discovery of lead corporate executives for no legitimate reason. So there was a split on the panel on the merits, but they unanimously certified the question to the Florida Supreme Court. And the question was, does a departure from the essential requirement of law occur when the so-called Apex Doctrine, which applies to governmental entities, is not applied to a corporation? So initially, the Supreme Court did take up review. They granted the petition to review the first district's decision. But then what they did is they exercised their discretion to discharge the jurisdiction in that case, and instead they did a rule amendment. So that's where you have the 1.280 H, and that's the new Florida Rule of Civil Procedure 1.280 H and the Apex Doctrine. And the rule they adopt, and I'm just going to read it, it's an important doctrine. A current or former high-level government or corporate officer may seek an order preventing the officer from being subject to a deposition. The motion, whether by a party or by the person of whom the deposition is sought, must be accompanied by an affidavit or declaration of the officer explaining that the officer lacks unique personal knowledge of the issues being litigated. If the officer meets this burden of production, the court shall issue an order preventing the deposition unless the party seeking the deposition demonstrates that it has exhausted other discovery, that such discovery is inadequate, or that the officer has unique personal knowledge of discoverable information. The court may vacate or modify the order if, after additional discovery, the party seeking the deposition can meet its burden of persuasion under this rule. The burden to persuade the court that the officer is high level for purposes of this rule lies with the person or party opposing the deposition. So that's the rule that the Supreme Court has adopted. And they really think, just like Judge Thomas reasoned in his dissent in the Suzuki case, that there's no reason to treat high-level government officials and high-level corporate officials differently. And really what the rationale of the Apex Doctrine is to I guess, to protect these high-level executives from numerous potential discovery requests, depositions for all sorts of issues. And what happens is that's going to, in the government context with the government head, that's interfering with government operations. And the court's saying that's not good, right? And that's understandable. And they've applied that to different heads of agencies, and they've applied it to, say, state university president, because that person can be subjected to depositions, for example, in employment disputes. You have numerous employment disputes, and so it's for protection. And what the Supreme Court, in their opinion, which I don't think they've given a Southern Third site, but you can find it, the 2021 Westlaw 3779161. But they went ahead and talked about the rules we're all familiar with. Florida Rule of Civil Procedure 1.280B, which is scope of discovery, which the court recognized our rules take a permissive approach to the availability of discovery. And second, you've got 1.280C with protective orders. And the rules have a liberal orientation, we all know that, toward discovery. And it's checked by the availability of protective orders. They say rather than limit high-level government officers to the generic protection of the protective orders allowed under 1.280C, the district courts in Florida have enforced the Apex Doctrine in the government context. So it's really by case law previously. Now and that's why this is a big deal. The Supreme Court's now codified it in a rule, and they're expanding it to cover the private sector as well. And I want to point out in the opinion, again, they emphasize efficiency and anti-harassment principles that really underlie the Apex Doctrine. So why wouldn't that apply also in the corporate spheres as well? And because such discovery does create a tremendous potential for abuse or harassment. So that's what they're trying to protect, not just the government heads, but also corporate heads. But there's still standards to be followed as the rule lays out. But, quote, we see no good reason to withhold from private officers the same protection that Florida courts have long afforded government officers. And they go by the federal district courts in Florida, who've made comments that, quote, by virtue of their position, Apex officials, quote, are vulnerable to numerous repetitive, harassing, and abusive depositions, and therefore need some measure of protection from the courts. Now, what's important are the limitations. This is in carte blanche protection, of course, and in the opinion, the Florida Supreme Court emphasized that the doctrine, quote, in no way creates a blanket prohibition on the taking of a deposition of a high-ranking corporate official. The point of the Apex Doctrine is to balance the competing goals of limiting potential discovery abuse and ensuring litigants access to necessary information. So properly applied, the doctrine will prevent undue harassment and oppression of high-level officials while still providing a party with several less intrusive mechanisms to obtain the necessary discovery, and allowing for the possibility of conducting the high-level deposition if it is warranted. So, the Supreme Court said it is in Florida's best interest to codify the Apex Doctrine in our rules of civil procedure and apply the doctrine to both private and government officers. Making this change as a rule amendment allows us to ensure consistency across the two contexts and to define and explain the Apex Doctrine as clearly as possible. So that's the state of affairs with respect to the Apex Doctrine, which will be of tremendous use to all sorts of individuals in litigation. Again, thank you for listening today and getting updated on the new change to the Rule of Civil Procedure 1.280. We invite you to let us know if you have any questions. Thank you again. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.